This courtroom video captures a sentencing hearing that quickly turns into a tense showdown between a judge and a defendant who seems determined to make everything worse for himself. From the very first moments, Mr. Tamayo's attitude sets the tone. Instead of showing remorse, he interrupts the court, talks over the judge, and repeatedly reminds everyone that he's from California, as if that somehow changes the reality of the charges he's facing in Texas. As the hearing unfolds, the judge patiently explains the seriousness of the case. Mr. Tamayo is charged with a second-degree felony involving possession of a controlled substance, a charge that carries real prison time. Despite being offered a plea agreement that limits his sentence, the defendant continues to test the court's patience with sarcastic comments, strange explanations, and non-stop complaints about his situation. Things only get more awkward when Mr. Tamayo launches into a rambling speech about personal losses, claiming he wants probation so he can help the community. Moments later, he makes a request that leaves the courtroom stunned, asking the judge if he can be sent to a California prison instead of serving time in Texas. The judge's response is calm but firm, making it clear that this courtroom follows Texas law, not Californian expectations. In the end, reality catches up fast. The judge delivers the sentence exactly as agreed. 3 years in prison, strict conditions, and no right to appeal. What could have been a straightforward hearing instead becomes a powerful example of how disrespect, interruptions, and poor decisions can seal your fate in court. This video is a reminder that when you stand before a judge, your attitude can matter just as much as the charges themselves.
Counsel, you received all discovery. Did you review that with your client?
Yes, Your Honor.
The court will find that the state is in compliance with discovery. Mr. Tamayo, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did, and I would like to address the court so I can just let you know what I'm doing in Texas. I'm from California.
Okay. I mean,
it ain't gonna make a difference.
All right, then maybe your attorney doesn't want to talk about what you're doing here. All right, counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Proceeding on count 2 waiving.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendant's Waivers with your attorney? Did you understand it?
Yes, ma'am.
Did you cite it in all the appropriate places?
Yes, ma'am.
Do you understand your charge of possession of a controlled substance, penalty group 1B, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yeah.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
I try not to, but yes.
Well, I mean, it's either you did or you did not. If you want a jury trial, we can set you for jury trial.
No, I just give up the rights.
All right.
Right?
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Tamayo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, but I would like to
Anyone?
tell somebody.
Yes.
I came to visit a cousin in July, and I was here only for a month. It took 5 months for me to see a court date. I lost my brother. I lost my cousin that I came to visit while I was in incarcerated. Lost my aunt. Lost my sister-in-law too. And I was hoping for probation. You know what I mean? Go to Victory Outcry and get a blueprint and help out the community. Give you guys a year and have the community speak for itself. You know what I mean?
All right. Well, what I can tell you is this is Texas, not California, and that's not the way things are done. The question is,
I also know what's constitutional. Not constitutional.
has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Nah.
Anyone promised you anything other than the plea?
I just finished doing 10 years.
All right, has anyone promised you anything other than this plea bargain agreement?
No,
Are you satisfied with the way you've been represented?
anywhere I can't complain.
All right, are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I understand it all.
According to the plea, state is proceeding on count 2. Punishment is to be assessed at 3 years in the prison. There's a $2,000 fine and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, there being such motions?
No, Your Honor.
Into the offenses charged in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers state's exhibit number 1 and attachments.
No objection, Your Honor.
All right, you may be excused. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same.
Excuse me, ma'am. I signed a paper to get extradited. They said 30, 60, 90 days. Am I gonna get extradited back to
Going
California?
to serve your time of in custody in Texas prison, and then they will transfer you.
I thought I was gonna get extradited before that.
All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will
Right.
find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Oh, hell yeah.
All
I
right.
love Texas. Yeah.
Court will sentence you to 3 years in the prison.
Mhm.
There's a $2,000 fine, time and money to run concurrent. There's to be no contact with Sandra L. Torres.
Why is that?
All right. Counsel, is there anything else with regards to sentencing?
No, Your Honor.
All right, did you review the trial court certification of defendant's rights? And I'm sorry, also no contact with Julian Rodriguez
How do you know that, dude? I met him that day.
and Christy Brown. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain, counsel, did he review the document?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is.
This courtroom video captures a sentencing hearing that slowly transforms from a routine legal proceeding into a tense and uncomfortable display of poor judgment, misplaced confidence, and open defiance. From the very beginning, it's clear that the defendant, Mr. Tamayo, does not fully grasp the seriousness of the situation he's in, or worse, he simply doesn't care. Standing before Judge Boyd on a controlled substance charge, Mr. Tamayo immediately sets the wrong tone, interrupting the court and attempting to speak whenever he feels like it, rather than when he is permitted to do so. Instead of listening carefully, he repeatedly brings up the fact that he's from California, making it sound as if that somehow gives him special status or changes the laws of the courtroom he's standing in. His body language speaks just as loudly as his words. He leans back, rolls his eyes, and swings in his chair, projecting an attitude that suggests boredom rather than fear of the consequences ahead. This is not a casual conversation, it's a sentencing hearing that will determine years of his life, but Mr. Tamayo behaves as though he's arguing with a clerk instead of addressing a judge. Judge Boyd, calm but firm, explains the charge against him: possession of a controlled substance, classified as a second-degree felony. The potential penalties are serious, involving years in prison. Despite the gravity of the situation, the defendant continues to interrupt, often speaking over the judge, forcing her to repeatedly remind him to wait his turn. Each interruption chips away at the patience of the court and reinforces the impression that he does not respect the process. The judge carefully outlines the plea agreement that has been offered. Under this agreement, Mr. Tamayo would receive a 3-year prison sentence and a $2,000 fine, terms that are significantly more lenient than what he could face if the case were to proceed further. The judge asks him directly if he understands the charge, the rights he is giving up, and the consequences of accepting the plea. After some hesitation and more unnecessary commentary, he confirms that he understands. Yet even as he acknowledges the seriousness of the charge, his behavior suggests otherwise. Rather than expressing remorse or taking responsibility, Mr. Tamayo begins offering excuses and explanations. He talks about his personal losses, mentioning family members he claims to have lost, and attempts to frame himself as someone who wants to give back to the community. He insists that probation would be better for everyone, claiming that incarceration would serve no real purpose. At this point, the courtroom atmosphere becomes increasingly strained. While defendants are allowed to speak on their own behalf, Mr. Tamayo turns his opportunity into a rambling monologue that drifts far from the facts of the case. He paints himself as misunderstood, unlucky, and unfairly treated, all while ignoring the reality that he is standing before the court due to his own actions. His tone comes across less as heartfelt and more as performative, as though he believes he can talk his way out of the consequences. The most surprising moment comes when he makes an unusual request that leaves little doubt about how disconnected he is from the situation. He asks the judge whether it would be possible for him to serve his sentence in California instead of Texas. The request hangs in the air for a moment, and it becomes clear that he genuinely believes this is a reasonable question. Judge Boyd responds without hesitation, reminding him plainly that this is Texas, not California, and that Texas law governs what happens in her courtroom. Rather than accepting the answer, Mr. Tamayo continues pushing, attempting to argue his way into a more favorable outcome. Each attempt only reinforces the judge's earlier warnings. Throughout the exchange, Judge Boyd maintains control, refusing to raise her voice or allow the hearing to spiral into chaos. Her responses are firm, measured, and grounded in the law, providing a stark contrast to the defendant's erratic behavior. Eventually, the court returns to the matter at hand, final sentencing. Mr. Tamayo confirms his plea of no contest, formally accepting the plea agreement. With that, Judge Boyd pronounces the sentence, 3 years in prison, the agreed fine, and additional conditions including no contact with certain individuals. She makes it clear that by accepting the plea, Mr. Tamayo has waived his right to appeal the sentence. As the sentence is read, the consequences finally seem to settle in. The casual demeanor, the interruptions, and the confidence begin to fade as reality takes over. The courtroom that once felt like a stage for arguments now feels heavy with finality. The judge explains that the outcome could have been far worse and that the plea agreement already reflects leniency. The hearing closes with a clear message. Courts operate on rules, respect, and accountability. Attempts to dominate the conversation, dismiss authority, or bend reality through words alone do not work, especially when the stakes are this high. Mr. Tamayo's behavior serves as a cautionary example of how not to conduct oneself in court. Rather than helping his case, his attitude likely reinforced the judge's resolve to enforce the sentence exactly as agreed. By the end of the video, the takeaway is unmistakable. Legal consequences are not negotiable through arrogance or deflection. When standing before a judge, every word, every gesture, and every interruption matters. This case is a reminder that the courtroom is a place where actions carry weight, and respect for the process can make the difference between leniency and a harsh reality.